Given that a few moments ago I claimed that it's unlikely that the majority of consumers going into a supermarket are going to be thinking carefully, sequentially, systematically about each product they actually buy, that's not the case at all. We make decisions in a matter of milliseconds, largely based on unconscious cues. So when we ask the judicial system to evaluate whether or not a product is claiming an unfair advantage or not, that seems to be a little bit screwed up, because we are essentially asking someone to spend weeks and weeks and weeks to think deeply about the merits of a decision that's made in a matter of milliseconds.
The model of lookalikes is driving the growth of the discount supermarkets in the UK. That's only set to continue. I think the exposure of lookalikes and the impact of lookalikes amongst consumers is only set to increase. Certainly over the cost of living crisis, doing nothing risks brands sleepwalking into a longer term brand value creation harm. And like I mentioned before, once you lose consumers to own brand equivalents or lookalikes, they're extremely expensive to bring back, even if you do get the opportunity to do that. For my view, it's about creating tracking research or updating existing tracking research to be able to fundamentally track the impact of lookalikes on your brands as part of your existing brand tracking framework, understand the value of your brands and the value at risk and the value erosion so you can take corrective or course correction measures. And therefore, having a provision for a budget to address all the things I've been talking about, I think is really, really important. And the last point is, I alluded to it earlier, these things are not mutually exclusive. It's not about pulling out or not going in, selling into the likes of Aldi and Lidl. These brands should be able to do that, but they should equally not have to deal with the impact of lookalikes as well. They should be able to create an environment where they should be able to do that rather than just being win-win for the likes of Aldi and Lidl.
Everything we do is brand. And the fact that the UK market seems to have got itself into the position where lookalikes are not only tolerated, but regarded as a bit of harmless fun by a lot of consumers is concerning, which is why we're trying to do something about it and just change people's perception of actually why these claims are important. What are they doing in legal terms when they mimic the packaging? Well, we've already spoken about with Steve, it's effectively a benchmarking exercise. Aldi themselves go on record as saying, we'll do the same but different. What does that mean? It means getting as close as possible to the brand so that it is recognised and has all of the impact that Steve's been talking about in terms of getting you to the product and buying the product. But it doesn't cause confusion. They've done a very good job of that. Confusion claims are very difficult to succeed upon in the UK. So that's their objective, essentially, is to avoid confusion. But that isn't good enough. And the way that the cases are going at the moment, confusion should never be the driving. I'm going to look at some of the right way to run these claims. Lawyers are obsessed with confusion. They throw in passing off claims. They throw in Section 10.2 likelihood of confusion claims. Why? Because they were brought up to do it. It's the wrong claim to bring for lookalikes, for reasons that I'll go on to explore. But the whole model that Aldi and Lidl and others have tried to operate is to make sure, firstly, they don't cause confusion for a passing off or 10.2 claim, and secondly, so that they don't infringe copyright. That's essentially what their model is. But the way the law is going on, unfair advantage and link, they've got a real problem. What are they actually doing? Way back to L'Oreal, which is a good 20 years old, the Courts of Justice said there are a number of things that trademarks do. They guarantee origin, yes, we all knew that. That was the traditional view. But also they have an advertising, marketing and investment function, and that's what they're exploiting. So they're essentially all the stuff that Steve's been talking about this attraction, the transfer of quality, all of the rest of it, that's what's being abused by the lookalikes. That is trademarkable. It's your packaging. I'll come on to how to go about protecting it and then enforcing it. But it is all free riding on trademarks, which gives you a claim for unfair advantage. I don't know if anybody remembers Fine Fare, but Fine Fare are a supermarket long gone. Their own brand products were all yellow. So baked beans were yellow, biscuits were yellow, and they had the name on them. Unsurprisingly, that wasn't very popular amongst consumers. For all of these reasons, you didn't know what they were, you couldn't distinguish them, you couldn't find them, you had to go and read the tin to see what it was. That's why they are exploiting the advertising and marketing function, because they get you there. Once you're there, you get the transfer of image, the transfer of quality, and you're buying it because you think it's an equivalent. That is abusing the marketing function that the trademark achieves. There has to be a link between the products. This is why confusion cases are not the way to go. Lidl versus Tesco yesterday, the judgment came out. 102-page judgment. Congratulations to the Lidl legal team for the volume of evidence that they put in on that case. About 80 pages of the judgment are analysing the confusion evidence. 6 pages, unfair advantage found. These are straightforward claims. Why people are insisting on running confusion claims, I don't know. It's a lower bar, unfair advantage. All you have to show is link. You do not have to show confusion. So wasting a lot of legal fees in running confusion when the bar is this low on unfair advantage seems to me to benefit only the lawyers. Transfer of image, easy. That's what Steve was talking about. Transfer of image is this abuse of the marketing function. So it's the packaging that has got you there. It's because you recognise the packaging that you're comfortable with it. You associate it with another product that you know very well, and you give it the same attributes. It's just cheaper. This thinking is what Steve was talking about. Judges are in this strange position. There's this sort of artifice in our legal profession that the judge has to put himself in the position of a reasonable consumer. We've got very sophisticated IP judges. They are very good on intellectual property. They are not very good on consumer behavioural science. So these comments are in the judgment of the interim decision. They are so out of date in terms of how consumers actually behave. This is the traditional thinking that Steve was talking about. This is, oh, well, name comes first. Name's more important. Brands are all about names. So when you look at AU Vodka, it's all about AU. The other, the lookalike that's being sued is NE10, which is neon and its atomic number. Totally different to AU. Nothing like it. Well, conceptually it's quite similar. But more importantly, it's the least impactful part of that packaging. That is very, very impactful packaging. And it's not because it has the words AU written on it. So this is, in a way, what we're up against in terms of judicial thinking. And it's why the sort of analysis that we're talking about today and just thinking a bit more creatively about these claims and what evidence to put in is so important, because the judges aren't averse to this stuff. There's a judge called Mr. Justice Newey, Commercial Court, who took on board a whole load of expert psychological evidence on how unreliable witnesses are, witness memory, witness recollection. 10 pages of his judgment is warning all judges, when you hear a witness, they're not trying to lie, but they're reinventing history because they don't remember it and it benefits them. So you should give far less weight to witness evidence than documentary evidence. So the courts they're persuadable on this stuff. They just need educating. Brands need to run the right cases to educate them. How do you go about proving it? Well, I'm a litigator. I would love to say with confidence, you don't need to prove much here because the law's all going in your favour. Link's dead easy. Reputation's dead easy. Link, they've deliberately targeted you. Their own disclosure will show they've deliberately targeted you, so you don't need to worry about evidence on that. Change in economic behaviour. obvious. If you need some help, Steve's up there. But joking aside, the research is all there in terms of the consumer behavioural science. So showing the change in economic behaviour is very easy. Now, I'm not brave enough to say that you should put no evidence in on these things. You obviously need to think about the evidence. It's quite easy to get. So on Link, it's a social media troll. It's what I was talking about. People chat about the lookalikes all the time. They're making that link. They're not confused. They're making a link. It's all you need. That also, by the way, is your transfer of image evidence as well. Change in economic behaviour is the one that I'm a bit more nervous about, and that's why we're sort of looking at all of these areas today, because it is there. You can show the change in economic behaviour. There's consumer behavioural science, research that shows it. But actually, the reported cases so far, the court hasn't needed it. It's just said, as a consequence of targeting these brands with your lookalikes, you're doing it for a reason. And you're doing it to change your own customers' economic behaviour. You want them to buy your stuff. That's good enough. So it's a really, really low bar.
We mentioned this in our report on post-choice rationalisation. Once they have made a mistake, not many people will raise their hand and be like, oh, yes, I've been duped. A lot of times people will actually justify that and say, yeah, I know I picked up the lookalike. I actually like it a lot more than the other one. So that's another factor to consider. Yeah.
That really resonates with me because Which did a big consumer research. This is going back a few years now. And sadly, it asked the question, it demonstrated a lot of consumers were confused, but it asked the question, are consumers bothered? And a lot of consumers said, no, we're not bothered, because they're not going to admit that they made a mistake. And they seized on that and said, well, this is not an issue for us because consumers aren't bothered.